Specifically, you could do that. Nickel, sure. Also pursuits. And I don't know if people worry about it. He's not in charge of it. It's just that he's able to use the crowd. Yeah. It's different. Yeah, it was place. And I don't represent on me. No, I have. There's a, did you say there's some water in there?
There is a, yeah, it's one of those little fun cups we're gonna take fair. I don't think they have, actually, you know what? Thanks. All rise. Court of Appeal, Linden Fourth, Fifth District of the State of Florida is now in session. The Honorable Harvey L.J., Chief Judge, presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, State of Florida, and this honorable court. Please be seated.
Afternoon. This is the afternoon session of the 5th DCA. We feel at home here in Duval County because we are all residents of Duval County. So that all fits, but we want to thank again the Fourth Circuit for having us, and what a wonderful courtroom. And we are utilizing, I believe, the video equipment, audio equipment of this courtroom, which has really enhanced our ability to be able to stream all of this in real time. Please remember that we are in session. This is a real courtroom and a real oral argument. So if everyone would be mindful of that, turn off your cell phones, any electronic devices that may interrupt the proceedings. That said, I believe, Mr. Russell, we're ready for the first case of the afternoon. Pine Grove ADG Holdings versus Roberts Diesel Service. That's case number 24-1759. Mr. Russell, would you like to reserve any time for rebuttal?
5 minutes, please.
Right, so noted. You may proceed.
Thank you. I was going to stand up here and first say, welcome home, Your Honors, but it sounds like you are home, or welcome to Jacksonville. Instead, I'll just say good afternoon. Appreciate this. With me is the principal of Pine Grove, the appellant in this matter. It's Ken Atwood. And we represent the appellant, Nicole Busey and Lanny Russell, Pine Grove. The appellant, Pine Grove, was the buyer in a large failed real estate transaction, and Roberts Diesel was the seller of that tract of land that did not sell. Hopefully, during this argument, I can refer to Pine Grove as it is the seller and the owner of the land. Pine Grove is the buyer, and the seller of the land would be Roberts Diesel. That should be clearer for everybody, including me.
I think on behalf of the panel, I think that makes a lot of sense, Mr. Russell. So please proceed in that regard.
Thank you, sir. The trial judge concluded that the seller did not want to close this real estate transaction. The buyer did not want to close the real estate. I'm confused myself. Buyer did not want to close this transaction. And that's just not a very plausible conclusion here. The buyer was to purchase from the seller of a large tract of land, that tract of land for $10 million. There was a simultaneous closing between the buyer and a third party at which the buyer would receive.
And I don't mean to split hairs here, but my review of the record, I didn't read the trial court judges saying that anybody wanted to do one thing or wanted to do another thing. My understanding is the trial judge simply found that the buyer failed to close within the correct timelines. Wanted may be a bit of an overstatement, no?
I'm trying to recall, because I thought she said the word want actually in the transcript recently. It didn't want to close the transaction.
Well, that's why I'm asking for a correction, because I may have overlooked that, but wanted to me sounded like an overstatement. If I'm wrong, then
Yes.
please do correct me.
I would be surprised, Your Honor, I'm questioning it, but it was very much the understanding that the fight was over who didn't want to close the transaction. And if it was just they didn't close, somebody had to cause that. It doesn't just happen accidentally, and it was much more than an accident here. But back to why I was saying the idea that the buyer, Pine Grove, wouldn't close this transaction is not plausible, is because of the structure of the transaction. Pine Grove was buying a large tract of land for $10 million. Simultaneously with that purchase of the tract of land, the buyer would receive from a third party an additional $2 million for the property. And as the third party, a home builder developer built out the 797 homes. An additional $10,000 would be paid to Kendale upon the sale of each lot. So,
Mr. Russell, as you know about perhaps this judge, procedural issues always intrigue me, and I see first up among your issues on appeal is a procedural issue, talking about the transcript being the basis of the reasons behind the motion for summary judgment, and or the granting of the motion for summary judgment, and I want to make sure I understand that. You would agree with me that the court directing the attention of the parties to the transcript is permissible. You would agree with that?
I would.
So as I understand your argument, you're saying that there is either ambiguity or outright contradiction in the transcript, And therefore, that would undermine the basis of saying on the record what the basis of the summary judgment is. Did I say that rightly?
Yes, I think that's as the rule says it itself. It does go on in the comments, though, to say that the judge is obliged to prepare the order. And I take obliged to mean the judge should do it. Obliged could be satisfied with very specific directions. But if you looked at the transcript, it was an hour-long or so hearing and a lot of back and forth and a lot of conversation with the judge. She was very active during the hearing. Very active with me particularly, and
Help me again, and I missed the last, you said obliged to what, the
I'm
comments say?
trying to read it, it's right in the comment, the judge is obliged to prepare the order, is what the comment says. And it says the rule must be strictly followed. And I'm familiar, I've seen it most of my 40 years, the judge telling one of the parties to prepare the order. But in this matter, I think with the new rule, and given the manner in which the hearing went forward, it was back and forth. And the judge made lots of statements, some of which never appeared in the order, and some of which may have. But there was also.
As I read the, and I'm just looking at the rule, I mean, the text of the rule, this is 1510A. The court shall state on the record the reasons for granting or denying the motion. I don't know how you could say it on the record any better than saying it on the record,
If
Mr.
you go
Russell.
down a little bit farther into the comments is where the obliged word is, Your Honor.
Well, and thank you for the comments, Mr. Russell. I mean, I'm more concerned, as you would probably imagine, with the text of the rule. And as I did a jet tour through some of the cases, it looked like every case I saw said that the court had the option of either saying it on the record or capturing it in the written order. Now, are you familiar with a band of cases? Maybe I didn't find. I looked at 8 or 9 of them. I could recite them if you want to see them. But I found last night that said either way was a good enough thing. Is there a case that says you've got to capture it in a written order, everything, the whole basis, the reason behind why you're granting summary judgment?
I read that into obliged, but that's me. It could be read differently. But in this case, the court didn't pause and state on the record why she was granting summary judgment. She talked some, and then at the end, she said, I listed them in the brief. There was a number of them, 4 or 5 potential reasons she identified, but none of those were in the seller's summary judgment papers. They didn't make those arguments. They didn't have the evidence that supported those arguments, and they couldn't be supported by the judge herself. They just weren't there. And it's A through D and 1 and 2 of things that are in the record that she said in connection with, I believe, making a ruling at the end of the matter.
I did see you made some arguments in your briefing as well about certain issues that she granted dispositive relief on were not pleaded. Is that an argument you're making here today in front of us? Pleading issues that were not properly put on notice about what you were aware of might have been happening?
Yes, sir.
And if you could just elucidate those for us.
So, find them. Some of these actually were errors or not in the record. The judge determined that the lis pendens, which caused the problem in this transaction when the sale was going to happen, was cured as a matter of law the moment the post-closing agreement was fully signed. And that's not accurate, Your Honor. The post-closing agreement didn't come into effect till it became operative. And it became operative when some property was purchased, went into the hands of the person, seller, and they satisfy, either one could satisfy the lis pendens. They had to get rid of the lis pendens. This post-closing agreement was fully signed, but the record's very clear. It was never funded. It never became operative. And one of the ways you can tell that, most of this is going on in the early part of the year, whatever year it was, in October and November. Well, the list pendants doesn't come off the record until December of the end of the year. And that's when the funding for the removal of the list pendants didn't come from the buyer, it came from the seller. So the list pendants did not immediately remove the list pendants. And that was one of the conditions of the, not surprising conditions of the purchase and sale agreement, that the title be marketable. And as we show in our papers, I believe, there's nothing much clearer than a list pendants makes the title unmarketable. And the other finding of the trial court that I don't believe was argued in their papers at all, the buyer agreed not to close on August 15th, 2022, because buyers signed the standstill agreement. Please look at the standstill agreement. The standstill agreement says words of one syllable. This standstill agreement does not affect the purchase and sale agreement. And the buyer, we'll see, this is a contested point, but the buyer through Mr. Atlee justified absolutely. They were prepared.
If a standstill agreement,
Sir?
if a standstill agreement read broadly doesn't affect a purchase and sale agreement, then what is a standstill agreement?
In this case, it had a particular purpose. They can be broader, as you just pointed out, that the parties not sell the property, the seller, and that the buyer not sue the seller while they tried to work it out. That was the purpose. Two things. A standstill agreement can be terminated by both parties if they wanted to. They're the only parties to the agreement. So if the seller says, I don't want the standstill agreement, I'll sell you the property today, 2 days early. And the buyer says, fine by me, I'll buy the property from you 2 days early. No breach of the agreement because both parties to it have agreed to move forward.
So the standstill agreement then is an illusory agreement? Because
I'm
you
sorry,
can't do
continue
that
on.
anyways.
I'm just not hearing you very well.
If the purchase and sale agreement is in place, he can't sell the property to somebody else anyways. If
Right.
that's the only thing he's agreeing to do, then you're saying that the standstill agreement was just an illusory agreement. If it doesn't affect the purchase and sale agreement, then it's nothing.
I didn't hear your question, Your Honor. I don't know if you turn your microphone up. I just can't hear you, sir.
Your position is that the purchase and sale agreement, the only thing you were requiring from the buyer was not to sell the property. They're already under that obligation by the purchase and sale agreement. So if the standstill agreement doesn't affect the purchase and sale agreement, then you're telling me that the standstill agreement was a nullity, that it was an illusory agreement, that it didn't mean anything. And I don't think we can read it that way.
Seller not agree. The contract had been performed. He argued that it had been breached by not closing, and then it's breached by the other party. Then in this case, the seller would be free to sell it. To stop that potential, they agreed to a short standstill while they, as they said, tried to work it out. And it went on to say it didn't affect the purchase and sale. But if both of them agree, it's not going to cause any issue. They've agreed, they didn't terminate the standstill agreement.
Did they?
And no, because they never got to the point of selling the property yet.
Which in a very roundabout way brings me back to our initial question. If putting the purchase and sales agreement on hold is not implicit in a standstill agreement, then what is a standstill agreement?
I think it is implicit in this agreement. My only point was there are two parties to the standstill. And with any agreement, the parties can say, we don't want that agreement anymore. We both agree to terminate. And free to do what they want with the property, sell it to each other or sell it to a third person. The other argument was made, I don't remember if the judge made this or the seller, because she made a lot of them herself. If you look at the transcript, you'll see that, is that section 3B of the purchase and sale agreement required the buyer to close within 10 days of the standstill agreement expiring. And that's not accurate. The buyer had to close the sale within 10 days of the lis pendens being dissolved, not the standstill agreement. Very clear in the purchase and sell agreement, can't have something that makes it unarguable. And the lis pendens was on the property for many, many months more after that point in time. And the seller offered to sell the property on two other later dates, November 10th, 2022 and December 31st. And at those two dates, the lis pendens was still on the property. And that was a condition precedent to the buyer being obligated to buy the property, that it be marketable. And it's about as clear in real estate as anything is in real estate. Lis pendens, properties with lis pendens are not marketable. That's why we put them in the title report.
Beyond defending a court case that may have arisen on notice of the lis pendens, what exactly was buyer expected to do?
So I'm terribly sorry, Your Honor. I have a bad ear. If I can step up here.
What,
Certainly.
what exactly was buyer expected to do? Besides defend any subsequent court case that could have arisen after the notice of the lis pendens. To remove the lis pendens, they basically have to say, no, you're wrong, we're going to defend our case. If that's all they do, what obligation have they not met?
Well, it turned out that wasn't the case here. It took the escrowing of $150,000 and the payment of $40,000 to get the holder of the easement to remove it from the property. The buyer had no idea what it would take to get that easement removed. They never offered.
When a buyer,
Sure.
any buyer receives the lis pendens, what are they obligated to do at that point?
Were they obligated?
What would have they been obligated to do under this PSA?
They wanted to use the area where the lis pendens was to the exclusion of the holder of the lis pendens. They couldn't do that. They couldn't build a road where the lis pendens was. They couldn't sell the property to a third party without lis pendens, the same reason they didn't want to.
What are you saying they should have done to cure the lis pendens?
Buyer?
No, what should have the seller done to cure the lis pendens that they did not do?
The seller was obligated under the agreement to make the title marketable. They should have gone to the buyer and done what the buyer asked for. They could have done it for, and the record is, they said had several opportunities to do it, and they chose not to. And they clearly could have done it for what it cost afterwards to do it, which was the $150,000 escrow.
So your position is buyer's obligation was to show Global their underbelly and say you can have whatever you want to make this go away.
They don't need to say that. They could go offer them a price and see what they said. They ultimately.
Are they obligated to go and offer them a price? As simply saying, no, we're going to defend our position here, enough.
The answer was, you can't obligate the holder of the easement to go remove it. If that happens, then the transaction at the buyer's option of the large tract of land doesn't go forward, doesn't have to go forward. The buyer could waive that provision and take the property with the lis pendens and own the property. The buyer didn't want to do that. The buyer wanted the seller to do its obligation and go make the title marketable and get rid of the lis pendens.
Proceed.
Mr. Russell, you are well into your rebuttal time because most of that was eaten up by questions from the court. I will give you 2 more minutes on your rebuttal and also give the appellees 2 more minutes as well if they're so inclined. But you can continue on, but we're about 3:30 left on your rebuttal now.
I got it. The comment to Rule 1.510, Your Honor, is comment D, and the wording of it, not Lanny's wording of it, is the court is obliged to make the order provided for by paragraph D of this rule. The entire rule is mandatory. The order must be entered. The order must specify the facts which are not controverted. And the judge never identified what facts were not controverted, and what she based her ruling on, and it's not in the final judgment either. The facts are not identified, which is clearly required by the rule. And you can tell that from the party's brief, Your Honor.
It's clearly set forth in the commentary. Now, I didn't see it in the cases and I don't see it in the rule, but I hear you. Thank you for reciting that for me, Mr. Russell.
Oh, I know what you're saying. If you look at the party's brief as a pair and look at what they're saying, it's fairly clear that the parties are guessing at why the court did what it did. There's no specific directive. This application of the law, it's just go prepare an order in accordance with the remarks on the record. And that hearing went on for at least an hour. And it was a lot of back and forth and a lot of inconsistencies within the discussion. The judge also, I didn't know quite what to make of this, as we were ending the hearing, and she was talking to me directly. She said, "We are not going to see the facts the same way. I get that, but it's just, and thank you for indulging the manner in which I have these hearings. It helps me to say all this out loud. It helps me to go back and forth with you guys on the facts. And in the effort to get it right, I hopefully did." And that sounds a lot to me like somebody who's resolving factual issues, not somebody who's looking for uncontroverted issues, arguing back and forth to the point where she thinks she's found the fact by the discussion. And that's not an uncontroverted fact necessarily. It could be, but that sounds like somebody who did a bench trial. It doesn't sound like a judge who just did a summary judgment hearing. The other point I was going to make, real quick, I have 42 seconds, is in the transcript. I didn't write on the page. I have a quote, I think. The judge said that Ken Attlee was at the closing. Ken Attlee was not at the closing. He was in Colorado. He had Friday before the closing from Colorado signed all of the transaction documents before a notary and had sent them to the closing agent, those documents. They were at the closing agent's office on August the 12th and wired to the closing agent the $10 million that was necessary to consummate the transaction. And no closing happened. The declaration of Ken Attlee, which is in the record, says, "Pine Grove was ready, willing, and able to close the sale of the Zero Garden Street property on August 15th, 2022. And what I just described is somebody ready to close the transaction."
All right, Mr. Russell, you have run through your rebuttal time, so if you want to close it in about 15 seconds, we'll hear you, and then we'll hear from the other side.
The thing I would ask of this court, and it's a tedious bit, and perhaps if you don't read the whole briefs, each of the briefs, it comes out, I think, more dramatically in the last 20 pages of the brief. And what comes out in that is the defendant in this case is not getting the benefit of an independent arbiter. He's getting the problem of somebody who from the bench is advocating positions that are the seller's, positions the seller didn't itself advocate or put in the record. And this is not the first time this has happened.
Thank you, Mr. Russell. On behalf of the appellee, Robert Diesel Service.
Good afternoon, Your Honors, and welcome to Duval County. My client's partner as well, Mr. Taylor, and his daughter. I can try to answer what I think some of the questions are. Go ahead.
Can I just ask one question up front? I'd like you to address one of Mr. Russell's last points. The order that we have in front of us says for the reasons set forth in the hearing. And then we have a pretty long transcript of that hearing. can you tell me exactly what basis, if we were to find for you, what would we be affirming?
Okay, the summary judgment is stating, it states, first of all, that, the, uh, the parties, did not expect an August 15th closing because of, there's an August 10 email which proposed that, the parties delay any closing and enter into a standstill agreement. And then the judge said, well, after that point, there was a certain amount of time where the contract here required 10 days after the resolution of a lis pendens to close. The court then said the appellant here, Pine Grove, cured the lis pendens because they entered into a binding written agreement with Global Signal, which would resolve the lis pendens at any closing. And that agreement, she read it very carefully. It says it does not have a termination date. It goes on and on. She also said that there were several points where after there was a bunch of title problems, things happened, and then after the standstill agreement, after they were trying to work things out, my client then offered to close. In October, they demanded closing by November 16th, which is 3 weeks later. Then when the appellant demanded more time, they said, we
Now-
need more time than that.
It may not be, particularly relevant to whether there was error below or not, but I'm curious if your position is those later offers to close, were those just uncontracted negotiations? Had the PSA expired already pursuant to the paragraph 3B clause when they gave what I think you characterize as a conditional response to your inability to cure?
Okay, well,
In other words,
definitely,
are you arguing there is a PSA in place, or are you arguing there is no PSA in place?
we were arguing there was a PSA in place. And if you look at the October demand, it says demand for closing. And it's addressed to Mr. Russell by me. And I said, hey, there's a contract, we demand closing. We want to close by November 16th, okay? Now, the second demand was in an email, which is in the record, and I can find it, but it is, that was something that is, there's a whole proposal to sign a separate document that would extend contract to December 31st. But the email, the cover page says, you have to close by December 31st. We need you to close, okay? Now, in all these things in the motions for a hearing, Mr. Russell brought up these several issues and actually filed various things in his briefs to the appellate court saying, I'm sorry, to the lower court saying, Judge Deering, look at this proposed contract that they said, that didn't give us enough time, et cetera, or something like that. So that's why we're bringing it up now. But definitely in the summary judgment motion, we had an affidavit of Robert Taylor, the principal of Roberts Diesel, saying, hey, we offered to close. We gave him 3 weeks notice to close in November, and we gave him 6 weeks notice to close December 31st. And the judge was very clear on that. She said, well, why didn't you close, Mr. Russell? What happened? Mr. Russell's response at the hearing and also to the response to the summary judgment was, well, we needed more time to obtain financing. And then getting back, did I answer your question? Hope so. But anyway, getting back to the issue of the August 15th closing. There's an email on August 10th from Coulter, which is copied to everyone. It says, Eric, I spoke to my client after you and I spoke. Coulter will be ready, willing, and able to close on the south parcel on the 15th, but is open to discussing alternatives, including purchasing the neighboring parcel to the west instead of the north part. In any event, Coulter is open to delaying the closing and entering into a 2-week standstill agreement to see if we can come to mutually agreeable terms. Putting that email out there, after that email, there is no other reference in the record. There's no demand, there's no notice of anything saying, oh, by the way, despite the August 10 email, appellant is now demanding closing on August 15th. There's nothing at all about something like, we're going to close before 4:30 on August 15th. And 180 degrees opposite, there was like a fork in the road. There was a proposal to either close or to enter into standstill agreement. Parties took the fork in the road. We go down and sign the standstill agreement. Everyone agreed to that. It's all there. Now, we didn't address, we did say that in our summary judgment motion. We said things were going along, there was this issue. We cited in the summary judgment motion, we cited the provision of the contract 3B, which requires a closing within 10 days of the resolution of the title dispute. We also stated in our summary judgment motion that the appellant admitted that the title issue was cured by the post-closing title agreement. It's in the summary judgment motion, and that's, I think, paragraph, it's in page 13 of our answer brief. What sets it out. But getting back to this issue, the parties never expected any closing on August 15th, and the key thing that would show you that is that the appellant never pled that as a breach of contract. Okay, the appellant in its breach of contract claim doesn't say anything about an August 15th closing. Okay, so when we have a summary judgment motion under the new summary judgment standard, we can prove the non-existence of plaintiff, we don't have the burden of proof. We can prove the non-existence of a genuine issue of material fact. The non-existence was that we didn't breach the contract. We did whatever we could do to close this contract. When we filed our motion for summary judgment, we filed various evidences and various things like that.
What did you understand your obligations to be when the Liz Pendants made the sale or the property unmarketable? What did you understand your obligations to be to cure that?
Well, we understood there was some issue, and the record does contain a letter from me to Global Signal saying, what do you want to resolve this? Okay, and that's stated in our brief. And the response from Global Signal is, we're not going to tell you. We're dealing with the appellant. Okay, the appellant had gone and done this thing. When it eventually came out as to what Global Signal actually wanted, they wanted a bunch of things that were non-monetary things that had to be agreed to by the appellant and Coulter. For example, they wanted a change in the easement terms. They wanted access 24/7 to this property. And the idea of this property is there's a dirt road, it's like a farm out there.
No, in short, they wanted things that weren't agreeable to you.
No, they were agreeable to us. We could not agree on behalf of the appellant to resolve those things.
Do you assert that there's nothing on your part beyond reaching out to them and saying, what can we do? And assumedly negotiating in good faith if they gave you a reasonable answer? What did you understand you were supposed to do?
We were there to do whatever we needed to. However, it's undisputed that appellant Pinesgrove never demanded of us to pay any money. They never said, you have to pay $47,000, you have to pay $150,000. Nobody said of us anything. Additionally, before the closing in March of 2022, Pinegrove's principal went and met with Global Signal. And they talked about the development and everything like that. At that point, Global Signal didn't demand anything, okay? And we were saying, well, look, Global Signal, you're gonna get a paved access, you're gonna get this new development. So everyone thought they were happy with what was going on, okay? It was only right before the closing that they started demanding things. And then at the closing, if you look at what was going on in the appellant's testimony, we said, what was the issue with the closing? Was it that we had to pay any money? He says, no, regardless of whatever was in the complaint, these things about the Global Signal Liz Pendants and everything else, or Pinegrove's duty to pay money, all we needed was more time. Okay, that was all we needed was more time to close.
And so that I understand correctly, you say that the defect was cured at which point?
We agree with the trial court that once this signed binding agreement, the post-closing tri-party agreement, was signed by appellant, Coulter, and Global Signal, that was it. It was cured.
So they had 10 days at that point to close the transaction.
Correct, but we put this in our summary judgment motion. The parties in August 10 agreed to delay the closing, which is what this email says. And there's nothing after that email saying, oh, wait a second, we're going to go back to August 15th. So
now,
go ahead.
And correct me if I'm wrong, this may have actually been a more appropriate question for opponent, but my reading of your opponent's analysis of the cure date would be that your deadline to close would be 10 days after closing. Is that correct?
No, I don't think so.
If you have to close within 10 days and it's not cured until closing, then wouldn't your deadline be 10 days after closing?
Well, the idea was that if you read the post-closing tri-party agreement carefully, it says, and I've got it right here, it says that upon closing, this is paragraph 5, it's record 732. On or before the date of the closing, GSA 4, that's Global Signal Cell Phone Tower Company, agrees to provide for the dismissal of the action, provide for the discharge of the lis pendens, and provide such documentation and assurances by the title company that the closing will happen. So they're saying at or before the closing, Global Signal is going to release the lawsuit and the lis pendens. So it doesn't have a delay. Does that answer your question?
Kind of.
Okay. And then going beyond that, before I forget too much, the action proceeded. Robert Cecil then got the action dismissed and the lis pendens resolved. Okay, it was wiped out. The action was dismissed, lis pendens was discharged. And that notice was provided to appellant on January 24th. Although it's not in our summary judgment motion, I agree with that part. But this was raised by the appellant in their response to our summary judgment motion. So Judge Deering then said, well, why didn't you close within 10 days of, if your argument is the lis pendens was still there, so we didn't have to close, why didn't you close when it was gone in January 2024? And the answer was no answer. I think there was some statement about they needed 6 months or something to get the money back, but that was what the judge said. She particularly looked at the contract, and she said, well, the contract that Mr. Atlee, on behalf of Pine Grove, selected, which is undisputed about that provides for a certain amount of time. If he needed more time, it's too bad. I do think that the judge could not at all provide some kind of a denial of summary judgment based upon some August 15th closing. That was not pled. If we did that, then we'd have to file another summary judgment motion and do facts, and that would eviscerate the summary judgment rule, because you could never get to summary judgment. They could come into summary judgment and say, well, I want to raise this unpled issue, and then we'd never get to a summary judgment. Also, the appellant never moved to amend their complaint, and the appellant at the hearing, they never expressed any surprise, saying, I didn't understand Mr. Kohler's motion. They never moved to continue the summary judgment hearing. So they knew what was going on. I think our summary judgment motion clearly set out what we were saying. It talks about these things, and it talks about a demand for closing. There was a letter, and it says, pursuant to the contract, we demand closing. So we're saying the contract's still there. Can I answer any other questions? Okay. Another issue here is the appellant has raised a lot of issues in their cases about a Vermont Lakes case, okay? And the Vermont Lakes case says that if the seller seeks to avoid a contract for the sale of real property based on existence of title defects, then the buyer is not entitled to specific performance of the contract unless the buyer shows that the seller failed to exercise reasonable diligence in clearing the title defects. And then reasonable diligence only requires the seller to act in good faith and appropriately in view of the circumstances. It does not require the seller to make extraordinary efforts or expenditures. The point of this case is that we are not saying in the summary judgment motion, I don't think the judge is saying that in summary motion, that we could have just stopped what we were doing on July 28th and said, well, we're not going to sell you the property anymore, okay? Our good faith went beyond that. We entered into a standstill agreement. We agreed to delay the closing as requested by everyone. And then we said, all right, we'll give you more time. And when the buyer said in October, after we gave them 3 weeks, they said, we need more time. We gave them another 6 weeks until December 31st. And not only that, but you're right about this issue of, it's kind of a settlement negotiation of this proposed deal that we're going to enter into, okay? But the point that is not a settlement negotiation is the cover facts on that. The cover facts on that offer. The cover facts on the proposed amendment. Okay, and this is, I refer to page 1131 of the record. This is a November 18, email from myself to Mr. Russell. I said, my client requires closing by 12/31/2022. And it also says, we'll give you a 45-day extension on the closing for an additional fee. So that is, that would extend the closing until February 15th, 2023. So we were bending over backwards to try to help them do their thing. And the answer from them was, no, it wasn't like, we'll show up or do something else. Another issue is that we addressed in our brief, if they wanted to say that we needed to pay something to Global Signal, they could have merely shown up at the closing and tendered the 7.5 million to buy the south parcel less $40,000. Okay, they never did that. In fact, if you look at the evidence, they weren't going to deduct any of the purchase price. They said, we're fine with what Global Signal wants. We don't care. Okay, so that goes back to our argument at summary judgment and now is that these, whatever they're saying that we breached, those were non-material breaches of contract. If there was something that we did wrong, it didn't cause any prejudice to the buyer. It didn't cause them any harm. And I asked Mr. Atley repeatedly at his deposition, what was the issue? Why didn't you close? His answer was, after August, we needed more time to re-verify permits. That's what he said. He didn't say anything about anything else, okay, and any of these other breaches of contract in the case. And that is not our issue because they agreed to extend the closing in August, okay? So if something was going on, they could have demanded a closing in August, but they didn't. They never pled that. There is some things about, we talked about the Corey, Your Honor, Mr. Judge Jay talked about the new standard for summary judgment. And there is some issues in their appellate brief that we have to do an extraordinary job of proving beyond reasonable doubt something. We don't have to do that. In Corey versus City of Tampa, it talks about that if you are the party without the burden of proof, which is what we are, if we come down and say your complaint cannot succeed, that you don't have any evidence showing that we breached the contract, then we win. Okay, so that's what we're arguing about here. And the judge is saying, basically no reasonable jury could say that you breached the contract. You offered them to close. You did what was required. And so I think at every point we did. I mean, our problem was, it wasn't a problem, but the appellant decided to go immediately to Global Signal, get this post-closing agreement hashed out and agreed to and signed. And under that agreement, that resolved the issue. So then the next thing that happens is there's a August 10 email saying, let's delay the closing and enter into a standstill agreement. Now the judge, Deering, she did say, well, she finds the post-closing agreement or the standstill agreement delayed the closing. But I think if you look at all the facts around there, the August 10 email, that there's nothing after August 10, between August 10 and August 15th, demanding a closing, and the standstill agreement that we're performing, the parties have this agreement, regardless of whatever the standstill agreement talks about the contract. The parties agreed. I mean, they had an agreement, they had a meeting of the minds, and the exchange of emails shows that. I do think that Judge Deering was, let's look at what she did. She spent a lot of time, if you read the transcript, you can see that she really went over everything at issue in this case. She knew everything that was going on. She looked at all the agreements and everything else. The transcript is 115 pages. She spent a lot of time on this issue before the hearing, looking at everything. Okay. She said that in the transcript, well, I'm not going to consider some evidence because there's something a little unclear about. I'm sorry, there's nothing unclear, but the appellant had filed a motion for summary judgment at the same time and then withdrew it the morning of the March 16th. So there were certain documents that were filed in opposition to appellate's, motion for summary judgment, he said, I'm not considering that because that's not part of the case. I then, provided her a proposed order, and, I think Ms. Russell objected to that. And so the judge said, well, I looked at this issue. She knew that she had to give a detailed, summary judgment that would be able to be reviewed by the court. And that is what she did. She said the transcript is really good on what I found, and it was fine. And then we cited numerous cases in our answer brief. Including Simmons versus Public Health Trail, 338 Southern 3rd, 1057, stating that the transcripts of the two, that it affirmed, even without a written order, saying that the transcripts of the two hearings showed the trial court stated its reason for granting summary judgment with sufficient specificity to allow appellate review. And this transcript is sufficient. It says, look, here it lays out the facts, and it says, she's not finding that we exercise reasonable diligence and we don't have to convey the property at all. What she's saying is that after all this bad stuff happened, Robert Cecil said, let's go ahead and close, and there was no closing. And that the contract requires, once those title defects are resolved, that the contract must be closed within 10 days. Do I have another minute?
I think we're done, Mr. Kohler, but thank you for your time, and thank you both. I would ask the next lawyers to let everyone clear out. I'm also going to inquire of my marshal or someone else as to what the beeping was out in the audience. I don't know, Mr. Gowdy, I kept watching you look around out there, so I don't know. I'm not suggesting it emanated from you, but I did notice you were looking behind you, so I don't know if we know what may have caused the beeping. Evidence card, maybe?
I don't.
Really?
It was definitely.
No,
I think so.
Well, and Judge Stout is right. Sometimes the evidence card, Aaron, which is on the left over there. Yes, if you maybe would look at that. Maybe Ben can help, an old hand in the courthouse. I wondered about that. I saw her read. I did notice that as well. That may.
Marshall, can we ask Mr. Russell if he got his briefcase here? He may have left that briefcase. Sorry.
No, that's very helpful. Oh, no. Have we figured out the beep?
Hearing aid that just left.
I wondered, and based on, okay, so it now makes sense. It may have been one of the people in the courtroom, so, and that person has now left. So I think we've got it solved. So thank you all. We're ready for our last case of the day, last case of the afternoon, Story Mountain LLC versus Ashco. That's case number 2024-2480. Are you Mr. Humbert?
Yes, Your Honor.
Nice to meet you in the courtroom today. Would you like to reserve any time for rebuttal?
5 minutes for rebuttal, please.
If we're ready with the recording, we can move forward.
Thank you. May it please the court. Paul Humbert for the appellant, Story Mountain. So jumping to the three-pronged test here under 1.540B, we don't need to discuss the meritorious defense because it was conceded. It's a very low standard to meet that. File anything pretty much. And, there's some cases that talk about general denials not being good enough, but I didn't dispute it in the trial court. And I'm not going to dispute it here. It's a conjunctive requirement. I know many trial judges over the years that have seemed to, implicitly, if you meet the meritorious defense, that somehow finds a way to morph into the other two prongs. And it's just not what the rule says. And I believe it's what happened here. I want to address it's not in the exact order that my initial brief is. My initial brief has the excusable neglect argument second, but I'd like to address it first here. The trial court, and there's a case that's cited. It's the most important case on this point. It's from this District Court of Appeals. It's the Joe Lynn Inc. versus LRG Restaurant Group case at 696 Southern 2nd, 539. Again, Joe Lynn Inc. We cited in our initial brief. It's not discussed in the answer brief. And that case is on all fours with what we have here. So we have a plaintiff in the Joe Lynn case.
And just so I understand, Mr. Humbert, and maybe this case says exactly what you're about to tell me, but here we have a vacator of the judgment by the trial judge. Did it happen in the fifth DCA?
Exactly. The fifth DCA found that the trial judge in that case had abused his or her discretion and reversed. And I acknowledge it's an abuse of discretion standard.
Well, and as I understand it, and please correct me if I'm wrong, boy, is it an abuse of discretion standard. It looks like, emanating from some older Supreme Court of Florida cases, it may be a gross abuse of discretion standard.
So this court addressed that in Emmer versus Brucata. I don't have the citation. It's not cited in anybody's brief. This court addressed that. That case, I believe, is in the last 20 years and said that it's surplusage. The Florida Supreme Court did use the term gross in a 1962 opinion, but that literally the Emmer case says that was surplusage. There's nothing in the case law that they believe that there's a different standard. There are judges who have said, well, just the term gross, implies that it's some heightened standard. But this DCA said in the Emmer versus Brucata, I might be pronouncing the Brucata wrong, but
No, that's helpful. The standard's important, Mr. Humbert.
standard is important. But the court was operating under the same abuse of discretion standard in the Joe Lynn case, which is why I think it's very illustrative. So in that case, the trial judge did exactly what the trial judge did here, which was they vacated their own final judgment. And in that case, I'm just going to give you a quick background because the facts here are much more indicative of a complete lack of excusable neglect than in the Joe Lynn case. So in Joe Lynn, the plaintiff serves the defendant with a alter ego lawsuit, claiming the two restaurants that the plaintiff was suing, that these two restaurants are an alter ego of one another. That's done on September 4th, 1996. 19 days later, so within the window to file a responsive pleading, the defendant, who's also a corporate representative of the LRG group, same here with ASHCO. ASHCO is a corporation. Here we have a corporation in the Joe Lynn case. The defendant responds with a letter that they fax and send certified mail. This is before 1997, so just before email. They send these to the plaintiff's lawyer and say, hey, we're not one and the same. These restaurants have nothing to do with each other. So, it was a sloppy attempt at an answer, but it was, the equivalent of a pro se answer. This court was unequivocal. If you have the benefit, you have taken the benefit of being of structuring yourself as a corporate entity. You don't have the luxury of taking that limited liability in one hand, and then in the other coming and saying, well, I'm ignorant of the law.
Well, but don't we have here, Mr. Humbert, what was characterized by Judge Wallace as a reasonable misunderstanding? And he actually found Mr. Ashurian, his words, not this court's, to be credible in his reasonable misunderstanding. So that sounds different than what you're describing to us.
It's not, because the appellee who ended up, it was reversed obviously by this court in the Joe Lynn case. They made the same argument that, hey, I thought that it was reasonable for me. And that's what the trial judge in the Joe Lynn case that was overturned thought as well. hey, I was reasonable in assuming that my letter to the plaintiff's counsel acted as a defense that would then preclude the entry of a judgment.
In our opinion, and I'll certainly read it, when we're done here, but in our opinion that you're referencing, does it say the trial judge found that testimony to be credible?
It does, but only if, this is where it's very important. This is going to be on my next point, but I'm glad you brought it up. Judge Wallace referred to that there was a conversation, a disputed conversation between myself and the representative of Ashko, Mr. Ashurian, when he called my office early on in the proceedings. So writ of garnishment served in November of 2021. Mr. Ashurian calls my office sometime in the beginning of January 2022. It's undisputed. I agree. We spoke. Judge Wallace, if you look at the transcript, Mr. Ashurian's testimony was that that I didn't inform him that he needed to hire a lawyer, therefore he was okay. And Judge Wallace, you can 100% accept Judge Wallace's finding that Mr. Ashurian's testimony was credible on that.
We have to, don't we?
We have to.
Okay.
But it doesn't answer the dispositive question, because he didn't, and this goes to the presumption of service that Judge Wallace never addressed. And I believe the discretion was abused by the trial court in not addressing it. And so when what the conversation entailed, Judge Wallace found that it was reasonable that Mr. Ashurian may have thought that the matter was resolved. That's what the order says. But make no mistake about it, the order does not go further than that. The order never addresses the 7 court pleadings that my office served on Mr. Ashurian. It doesn't say that the trial court order never addresses those. And the trial court order says, it doesn't determine, the trial court says, okay, well, these documents, Mr. Humbert testified that his office serves them, and my office manager testified that we serve them in the, as we state in the certificate of service. But Judge Wallace never makes a determination as to who.
Well, and stop me. I've got his order in front of me. My recollection of it, though, and I can find it if you don't recollect this, Mr. Humbert. My recollection, though, is he not only found Mr. Ashurian to be credible, he also found credible the fact that he said he only received 2 documents.
He acknowledges he doesn't have a finding that's credible, because he would have to have said that my office did not send the documents. This is where the presumption, and it's argued in the answer brief that I never.
Well, couldn't you have both? Couldn't you have a situation? I know your point is we send a lot of documents, but just say hypothetically, you send 1 document and the other person says, oh, I never got the document.
Correct.
Couldn't it be I sent it and they never got it? I mean, are they necessarily mutually exclusive?
They're not mutually exclusive, but the presumption is that and it is a rebuttable presumption, albeit a difficult one. The case law is clear that it's a presumption that the documents were served. Nowhere in that opinion does Judge Wallace go into the presumption. It was ignored by the trial court. I brought it up in my closing argument. It's in the transcript. We cite to it in our reply brief exactly where now in the answer brief, the appellee says that it was waived in the lower court. I vehemently disagree with that because I was there in the trial court. I said it. It's in the transcript. I said, Judge, there's a presumption that these are valid, and that's never addressed in the trial court's order. The trial court simply says, I find that because Farsi is Mr. Ashurian's first language, although he's lived in the country for many decades. I spoke to him. He speaks perfect English. It may be a little bit broken, but it's good English. He said, because of that, I can understand the confusion when him and Mr. Humbert had a conversation. Nowhere in that trial court order are you going to find, we believe that, or the trial court finds that those documents were never received. There is a recital where the judge mentions and it goes over the background, but you'll notice there's no distinction. There's no talk about presumption. There's no discussion of who was right and whether they were received or not received. It simply states in a one-line conclusory way that, not even a conclusory way, it's a background fact. Mr. Ashurian states that he only received 2 documents. But there's no, if you apply the presumption that it was legally required to be applied.
So and thank you for that, Mr. Humbert. So it is, and I remember reading that. He stated that at the hearing, Mr. Ashurian, that he only received 2 documents.
So it's interesting. It's obviously, again, I understand we have to accept the findings of fact. I don't believe there's a finding of fact one way or the other on that. But Mr. Ashurian was pretty clear that so there were 7 documents served. He says, I received the one from your process server, and I received the last one, the final judgment, but I received nothing in between. There
So,
was one.
so he did say that.
Except for the request for admissions, he was the testimony is very cryptic. So I asked him, and he says, well, I don't recall, I'll get you the exact quote if you want, but it's something along the lines of like, I don't recall receiving it. It's a bit of a hedge. And, but if you look at this through the lens that the trial court should have looked at it through I should have been given the legal presumption I'm entitled to. It's clear on the face of the order that I was not. So the presumption is that these documents were served. Imagine all the effort that went through. I mean, on page 17 of the brief, we outline these 7 documents that we served. Okay. To this day, the subpoena for bank records that would have proven the meritorious defense and the employment records, those have never been served.
So you get a presumption, but it's a rebuttable presumption. He testified, that's testimonial evidence, and the judge found it credible. What are we arguing?
He found it credible that he was confused about the conversation we had in January of 2022. He never found it credible specifically and never discussed the presumption regarding the documents. He makes reference that was his testimony, but there's absolutely no discussion about, because if there's a rebuttable presumption that I sent him, could any reasonable person conclude, we don't know because Judge Wallace didn't say, could any reasonable person conclude that those 5 documents that Mr. Ashurian says he doesn't get, and it's understandable why he'd say that because it would be the death knell to his case. So it's understandable that you would not want to testify to that.
But the judge did find him credible, and he did testify that. So if he testified that, the judge found it credible, then your presumption is gone.
But the case law says that simply
Unless
testifying that you didn't
unless
receive
you're asking us to reverse the judge's finding.
I don't believe the judge made a find. The judge did find him credible as to a very specific conversation where the judge makes no mention of, was I credible or not? We don't know because there was no presumption. The judge, the trial court should say, I find Mr. Humbert's testimony, despite the presumption, to not be credible, and my office manager to not be credible. Or to say that given the circumstances, right, that given the circumstances, there's enough here that I believe that that the presumption was overcome. We cited in our reply brief the case, I believe it's the Bergens case, I could be mispronouncing it. It says that simply saying you did not receive is not enough to rebut the presumption. It can be if there's other evidence, in the record. But here, that's not what Judge Wallace was doing. He's simply looking at.
Weren't there different service mechanisms? Some of the documents, for example, just the e-portal, e-service portal.
The only document is, and there's no requirement that we do it. My office never does it just because it's not required on the rules, and it's the actual clerk's default is the only document that's not. Sorry, and I acknowledge that it was never. I don't claim to have mailed it. The clerk didn't mail it. I agree. And in the Joe Lynn case, which again I urge this court to. Do you want to stop?
Sorry about that. Please proceed.
In the Joe Lynn case, it's the reason that case is so important is the Cedar Mountain case that's relied on primarily regarding and that's the second issue that I'd like to address, which is the due diligence. The excusable neglect is addressed in Joe Lynn. If you look at those facts and you look at our facts, the Joe Lynn, the losing party in Joe Lynn, the defendant, he didn't show up to the hearing because he thought, I was excused because of the letter that I faxed that said that these entities are not the alter ego. He thought that his informal communication with the attorney excused his compliance. That's exactly what Mr. Ashurian did, except it's worse because it was a phone call. It wasn't even a court pleading. Why would anybody think that after we had a phone call, if this thing was really resolved like he believed, why did my office serve him 5 consecutive pleadings after that? That doesn't make any sense. That is an abuse of discretion. And I agree that's a heightened standard. I think that we win because the finding's not there. The rebuttable presumption is not addressed. That's more of a de novo issue. But even if you really want to pick apart and do, hey, abuse of discretion is a heightened standard, these are unreasonable findings. It's an unreasonable finding to say that an attorney that I say in a certificate of service, and the reason I take umbrage with it is because it's my firm, and if I say I mailed something, I mailed it. And my firm and my office manager is the same way. And we mailed it, and this gentleman comes in and says, "Well, I don't know. I didn't receive it. I don't recall." Very ambiguous. So I agree that it's a very heightened standard to find that the judge abused his discretion in the findings of fact. But if you want to assume that Judge Wallace, if we want to say, hey, he did give you the presumption, although it's not addressed in the order and it's clear that it wasn't done. But even if we give every benefit of the doubt and say that the presumption was given and that he really weighed the testimony between my office and Mr. Ashurian, if we want to give all the benefits of the doubt in favor of the judgment debtor appellee, it's still an abuse of discretion. It really is. And that's exactly what the court did in Joe Lynn. So it is an abuse of discretion to find those 7 documents, but, so why would my office, if we really are in the game of not mailing documents that we say we do, the document that would have been convenient not to mail would have been the final judgment itself. Like, so we mailed the final judgment and we personally served the garnishment, but all these documents in between, we never sent. It is the epitome of an unreasonable finding. But again, that is a secondary issue. The main issue is that we were never afforded the presumption by the lower court of the validity of the certificates of service. The finding of credibility of Mr. Ashurian is only as to that phone, is only addressed, and you can read the order, and I've read it many times trying to, because I figured you guys would ask that question, but it's only as to the phone call that he had with me. And I agree with Judge Wallace on that, by the way. I can understand where somebody would be confused if you're not an attorney. I don't think it's excusable. There's a whole other line of case law we cite on that. See, you have the limited liability that you take, it's not a constitutional right to incorporate as a corporation in this country, in this state. It's a legislative gift. And so you have the right to protect yourself from creditors and everyone else by incorporating, and you have an in-house counsel. This is all in the record. They have in-house counsel, multiple in-house counsel. One of them is here today. Outside attorneys, accountants. This is all in the record. It's all in the cross-examination of Mr. Ashurian. This is a sophisticated commercial entity that owns numerous, and their affiliates own numerous commercial properties in the state of Florida and in this region. So, but yet they're excused from having to comply with any court, never even producing a single document responsive to a subpoena, and then just showing up. And I know I'm eating in my rebuttal time, but I want to make one final point. The due diligence, there is nothing diligent. So if we went on excusable neglect, which I believe we do, especially after the Joe Lynn case, and I should have made a bigger deal about it in my brief, candidly. I should have been given even more discussion, but we do cite it on page 9 and 10. If the due diligence, there's nothing diligent about filing a unverified motion and then waiting until the day of the hearing, 67 days later. That's not, obviously, Mr. Gowdy's firm has nothing to do with this. This is a separate trial counsel.
Well, in the whole unverified thing, and try as I might, I don't see a word of that in the rule. Not a word about having to verify the motion. I mean, you strike me as a smart person, Mr. Humbert. I mean, the rule doesn't require it to be verified.
It's not specified in the rule, but the case law, a lot of the one case that says that it doesn't is a per curiam opinion from this court, which is their best case.
Well, but no, I hear you, but we have a rule dedicated to this issue and another rule, 1030. I mean, that says, unless we say otherwise in these rules, there is no verification requirement and no affidavit requirement. Wow. I mean, so, and I know there are rules. Sham pleading is an example of where you have to have a verified motion, but there is no requirement in this rule that it be verified or that affidavits be appended to it. So, I mean, cases that say that, with all due respect, I disagree with it because I think the rule just doesn't require verification. Now, perhaps your argument is beyond that. Perhaps you're saying, even if you assume it didn't have to be verified, it was still not diligent of them to handle it the way they did. But help me understand, if it's not in the rule, how it's required.
I'm going by what there's the case law says that. I agree. I'm a textualist myself. I don't, I'm with you. It's not a statute, it's a rule. So I think there's a little bit more liberality with it, but the case law says that. I didn't go back and look at the origin of why they said what they said.
I just,
on the other side, I'd probably be saying the other.
Well, in 1030, I mean, if we don't say it, you don't have to do it. So I think that's game, set, match. But I hear you. So tell me beyond what the rule requires, and we'll give you a couple more minutes, Mr. Humbert, because we have asked you some questions. But explain to me, if we assume it doesn't have to be verified, and I think the rule's clear on it, and no affidavits have to be appended to it, why this law firm, this entity was not diligent in trying to set this thing aside?
Because even under the Applebee's best case, which is the Cedar Mountain case, it's their best case. My best case is Joe Lynn, their best case is Cedar Mountain. I agree. It's a per curiam opinion, and it goes against some of the other opinions, but it was from this District Court of Appeals. But that opinion even says that if you're talking about the it says what you're saying, Judge, which is, hey, it doesn't necessarily have to be verified. It can be supplemented, sort of thing. That opinion says that the motion itself still needs to recite facts that, if proven true, would support a finding of excusable neglect. if you pay very careful attention to the original motion filed by the trial counsel for the appellee, you're going to find that an averment of that that they're not indebted. They addressed the meritorious defense that the original judgment debtor wasn't indebted, that he had passed away at some point near the end of the before, right after the writ of garnishment was served, but shortly thereafter, and that upon the appellee being notified of the final judgment on May 10th, 2022, that that 9 days later, they filed a motion. There's nothing about those 7 documents. This is why they do blend in with each other, the excusable neglect and the due diligence. There's not one word in that motion that discusses hey, I didn't get any of these documents. Nothing about why those documents were all ignored. Or the fact that 2 years later, we're now 3 years later, and they still hadn't produced documents that we had lawfully subpoenaed. So there was not one word about that. It doesn't meet the requirement of even their best case, which is the Cedar Mountain case. So if you look at that original motion, the original motion to vacate filed by trial counsel, it's just not there. It doesn't even meet the Cedar Mountain requirement. Again, if Your Honor's taking the position that the affidavit or a verification is not required at all.
I'm not taking that position. The rule takes that position, but go ahead, Mr. Humbert. Thank you.
So
Yeah.
if we accept that premise, it's the due diligence argument there is much more favorable for them than it would otherwise be. I can see that, but they don't win on excusable neglect. They can't. If somebody can find me an example of more inexcusable neglect than ignoring all of these court papers, and if the trial court had provided me the presumption that I requested and addressed it then I agree that I would have a much more difficult burden, because that would be a straight abuse of discretion, and that would be hey, look, maybe we don't agree, but we're not here to change the facts are the facts, and this is not a trial court, this is an appellate court. But we don't even get there because they never even talk about the presumption in the trial court order. That's the original sin.
I have a habit sometimes of asking questions that I admit have no relevance to your legal issues, but I do just kind of have to know, has anybody confirmed is or is not Mr. Ireland actually deceased?
There's a death record, so I'm going to assume.
Okay.
Yeah, he died on December 28th, 2021. So a few weeks after the writ was served. Correct.
Mr. Humbert, I want to be true to my promise. I'll give you 2.5 minutes for rebuttal. That means Mr. Gowdy has 2.5 extra minutes as far as his argument is concerned. But if you are finished, I'll give you 2.5 minutes for rebuttal.
Thank you.
Thank you, may it please the court. The death certificate is in the appendix. It's there, and I can get the exact site. And it seems like we all agree he died on December 28th of 2021. I just want to start by saying this is the first time I've argued against somebody who was a witness, trial counsel, and appellate counsel. And I appreciate Mr. Humbert's passion, but a lot of I know the court will do this. You'll parse through when he's conveying personal knowledge to you and what's actually in the appendix. I was neither trial counsel and I was not a witness. Just one example, he told you there's all this evidence that the company has all these lawyers. It's not in the appendix. Mrs. Shurian is here. She is counsel. Her name's not mentioned anywhere in this record. So I don't know why he felt the need to tell you that. And I think there's lots of other examples, but I won't have time to go through them. We just ask the court to look closely at the appendix. I want to start big picture, and I want to start with the text of the rule, Judge Jay. I think you've identified it. And I want the 3-part test, and we're here only on 2 of them. You have excusable neglect and due diligence. And I would like you to look at the rule to see where those 2 elements come. And it's Rule 1.540B, and under subsection 1, well, let me start actually under the heading, or the B part. It says the court may relieve a party from a final judgment, that's what we're on here, for the following reasons. And then under 1, it has mistake, inadvertent, surprise, we're not on any of those, or excusable neglect. Okay, so that's part of it. Now, where's the due diligence in the rule? Well, if you jump down, you'll see the motion shall be filed, not prosecuted, filed within a reasonable time. And it says for reasons 1, 2, and 3, which we're under 1 here, there's a cap on that, 1 year after the judgment. Now, I'm going to jump to his first argument in the brief and that he finished on. The way I think of this temporally is excusable neglect is everything up till the final judgment, which in this case was May 10th of 2022. And the due diligence is everything from the entry of the final judgment to when you file. So that's what the rule says, file the motion to vacate. The motion to vacate was filed 9 days after the final judgment. And it was filed by the undisputed affidavit in the record from Mr. Alan Ashurian. It was filed 2 days after receipt of the final judgment. So what you hear about the due diligence argument that you heard at the end are about events that happened after the motion to file, motion to vacate. And how that, Your Honor, respectfully, none of that falls under Rule 1.54B. What that might fall under is the court's case management powers under Rule 1.420E, which deals with a failure to prosecute. And if you read what Judge Wallace said at the hearing, he apologized for how long it took for this to get decided. He said, "I regret the court's role in this and the participation in this. There's no excuse for the lack of action." And I'm not here to, I like Judge Wallace, I'm not here, but there were some administrative mistakes. It's all documented. Mr. Alexander, who was trial counsel, filed an affidavit about the numerous emails that went to the judge's JA, and there was no response, all that. But, Your Honor, none of that has anything to do with the due diligence requirement at all. Because what the text of the rule says is you have to file within a reasonable amount of time. Once you file, then you stop that clock and you fall under the rules dealing with lack of prosecution, which we aren't even arguing about. And I want to make clear one other thing. It's escaping me here, but that we're only here on the motion to vacate. Judge Wallace also entered some orders in this same order on lifting the admissions and discovery and all that. You don't have jurisdiction to review any part of that order. And that's what he's really complaining about, I think. But it's not before the court. The question is whether there was excusable neglect leading up to the entry of the final judgment, and then whether there was due diligence in filing the motion. It's not a failure to prosecute case.
What say you, Mr. Gowdy? You heard the argument about these documents that were sent, according to Mr. Humbert, from his office, and Mr. Shurian said, "I didn't get them." Why does that not undermine the excusable neglect analysis of Judge Wallace?
Well, I do think there's evidence that undermines the excusable neglect, but the judge is given deference on the factual findings. And I want to go through those documents with particularity. As far as the 7 documents he's talking about.
Let me real quick pick your brain on standard of review. I know our standard review here is abusive discretion, perhaps with some surpluses, maybe gross abusive discretion. Is that top down for the entire issue? Are the constituent parts of the judge's decision also under that same standard of review? Specifically, where a judge finds that something is excusable, is that a question of law, a question of fact, or a question of equity? Should we be looking at that for abusive discretion, or should we be looking at that de novo and then deciding the ultimate question as abusive discretion?
It's all abusive discretion. I think the only thing that would ever probably be de novo in this context, which he's conceded on, is the meritorious defense.
Well, I think your opponent would say that based upon the case law he has, that our review would say that you can't have a reasonable finding that this was excusable, thus it becoming a question of law, which I think we would review de novo, and then that constituent part of the analysis would inform whether it was abusive
Well,
discretion or not.
I guess the way you framed it, you can always frame something to make it de novo if you're gonna, I mean, it's sort of like when you're reviewing a jury verdict. You're saying, as a matter of law, de novo, could a reasonable jury reach that finding? So if you want to say you're reviewing whether the judge had a reasonable finding, and you want to call that de novo, I guess, it's just like, but you still got to give deference to the finder of fact. And I kind of want to get into the, about that, because in the reply brief, Mr. Humbert cites the Scuteri case that he talked to you about a minute ago, and this gets into the presumption that you're bringing up. And I would just say those documents only deal with excusable neglect, because all the documents he's talking about were served before the final judgment, so they don't have anything to do with the due diligence, okay, which was only a 9-day period, when we received it. But first of all, he keeps telling you 7. 2 of them are the same. They're the original writ with the subpoena that was served on Mrs. Ashurian on November 29th, 2021. And you're right, you read it in the order. We conceded that we received that, but he lumps those together to get to his 7. And then the last one that we concede we received is the final judgment, which we reacted very quickly. Got it to council the same day. That's Mr. Alan Ashurian's affidavit, and the motion was filed 2 days later by the ABB law firm. So the 4 documents in the middle that he's making a big deal of are the request for admissions, 2 notices of hearing, and the motion for entry of final judgment. And he's saying, hey, I certified by mail that they were served on Mr. Ashurian, and therefore we're going to presume that they were received. And that's true. He didn't quite articulate it this way below. There's only one sentence in the entire record where he's preserved this argument, if at all. And I'm going to tell you in a minute why he hasn't, but I'll just concede that for now. And he threw the word out prima facie, which means if you look it up in Black's Law Dictionary, it can be rebutted. And actually it says it in the case he was citing to you, Scuteri. Because so he reads this part of the case. This presumption is not overcome by denial, even though sworn that the order was not received. So he's quoting that to you. Turn the page. In other words, the denial of receipt does not automatically overcome the presumption, but instead creates a question of fact which must be resolved by the trial court.
And you're saying, Mr. Gowdy, Judge Wallace resolved that issue of fact?
He did, as you've already pointed out. He says on it's Appendix A8, page 3 of the order. He says that Ashurian denies receiving, and he lists the documents. And then he says he testified the only 2 letters I received regarding the garnishment were the original notice and the final document. And actually, he didn't just say I didn't recall. Maybe that's his memory of it, but that's not what I'm reading from the transcript. You can find this all at Appendix 291, 293. He said, I have not received anything. It's not some equivocation. I recall receiving 2 documents from you. One that I immediately called you on. He's talking to Mr. Humbert. The second, I immediately informed through my son to give that document to my attorney. Those are the 2 documents, original garnishment and also a letter that said garnishment was completed. As soon as I got the letter, I think he's referring to the final judgment, those are the only 2 letters I got, Your Honor. That's what he testified. And Judge Wallace then put this statement in his order. And so what are we hearing now? We're hearing that Judge Wallace didn't make explicit findings that that statement was credible. Well, if he wanted to preserve that argument, which by the way, he only really raises that for the first time in his reply brief, he throws out this presumption in the initial brief. But then at his reply brief, I got it here, he throws out, so on the bottom of page 4, he goes, but the 4 corners of the order make clear that never occurred. the trial court's failure to consider this presumption of service is violated. So now he's complaining about the four corners of the order. And we didn't, I will say, we didn't brief this because it came up in the reply brief, but that's saying if you're going to complain about the findings in the order, you got to file a motion for reconsideration or rehearing, which he never did. And that's what this comes down to. So I think this is all.
So, even though he verbalized the argument, he didn't file a motion for rehearing, reconsideration.
No,
So
sir.
therefore, that argument has been waived.
Yes, sir, correct. Never, and he raised it for the first time in the reply brief. Because what he's not, all he raised in the initial brief was the presumption. But what he's really complaining about is that the judge's findings weren't more specific. I also want to go, we're seeing this repeated here today. So he got up on oral argument and told you that the Joe Lynn case was his best case for excusable neglect. In his initial brief, Joe Lynn is cited only on pages 9 and 10, and that's under the due diligence argument. So no wonder we didn't address it in our answer brief. And I just did a word search through the appendix. It was never cited below. So now he's shown up at oral argument to tell you that this is the best case for him. I don't know if you want to call that preserved or not, but it's certainly not really what I'd call fair tactics. But I got a chance to read it, and what happened in the Joe Lynn case is there was not an argument that the matter had been resolved. What the party served had said was, we thought our letter would be construed as an answer. That's not our argument. That's not what Judge Wallace found. He didn't find that Mr. Ashurian thought he had answered the writ of garnishment. Mr. Ashurian, a non-lawyer, who, as long as he's been here, Judge Wallace is finding, despite, he gave you personal testimony about what he thinks Mr. Ashurian's English is. You heard that today from this podium, completely improper. Judge Wallace made a finding on that. You have to respect it. Mr. Ashurian was of the opinion that the matter had been resolved based on the conversation. And if you read the transcript, one of the things that got brought up was that he kept faulting Mr. Ashurian for saying that he didn't know Mr. Iron. He was offended by that. Counsel was, witness was. And Mr. Alexander tried to suggest to the judge that what Mr. Ashurian might have been saying is, I don't owe Mr. Ireland any money. No, owe. And the record here, I know he doesn't want to talk about the meritorious defense, but it is worth, I think it's part of the, it is part of the analysis.
Well, and let me, I had planned to ask you this. I will certainly ask Mr. Humbert this and give him the time to answer it. There seems to this judge, I can't speak for my colleagues, there seems to this judge, and doing a jet tour through the federal cases last night too, an equitable component to the rule. And talking about terms that are just, for example, to B1. Is there an equitable component to the analysis by the trial court in a B1 analysis, 1540 B1 analysis?
Yes, I think so, because of the terms of art that are used there that are very broad: mistake, inadvertence, excusable neglect. And the case law certainly talks about.
And the Fed, just to let you both know, the federal cases categorically say that this is quintessentially an equitable analysis. And so I saw there was some mention by Mr. Humbert, I believe, either in his initial brief or his reply brief, about the statement by Judge Wallace that, let me see if I can find it, that he just wanted, the court cannot help but observe that a refusal to vacate the garnishment judgment would result in a significant forfeiture or sanction being imposed on AASHTO, et cetera. This is on page 8. Yes, and he took exception with that. But again, if there is an equitable component to this, is that not somewhat part of the analysis? And that's my question, Mr.
Well,
Gabbard.
that's why the meritorious defense component is there, and he doesn't want to talk about it by stipulating to it. I will say the meritorious defense element is the only non-textual element of the three-part test, because it's not in the rule. I do think it makes perfect sense, because if you don't have a meritorious defense, why are we vacating the judgment? And I think it's the reason the courts have considered it is for what you're getting into. And let's just say it, Mr. Ireland was not our employee at the time. There's no evidence that he was. There's no evidence of any unpaid wages. This is a 2013 judgment, when at that point in time, Mr. Ireland was associated with ASHCO, and they're trying to, and he died less than a month after this writ was served.
So-
And they're trying to collect $500,000 from ASHCO for that.
Is that part of the trial court's analysis?
Yes.
Mr. Gaddy?
Yes.
That,
Sorry
that's
if I didn't
big.
answer that directly.
No, no, that's, thank you for being direct. I must ask Mr. Humbert the same question.
There's nothing wrong with that. I don't think court judges should bury their heads in the sand as to what's really going on here.
That is, so you would say that's baked in the rule. Now, the federal cases, the Federal Circuit Courts of Appeal, arguably the SCOTUS has said it's baked into the federal rule, which is substantially similar, maybe identical. I didn't go word by word, but.
It is very similar.
Yeah.
It's Rule 60 under.
Yes, and B1 is, I think, identical, and the cases, again, are legion, saying that equity is a feature. Second question, Mr. Gaddy, and I will ask you that same question, Mr. Humbert, in a minute about the equitable component. Gross abuse of discretion.
Right.
Is that a thing or not? Is that our standard here or not?
It's what the Florida Supreme Court said. In all candor, I'm not a big fan of adjectives and have never understood when that word is tagged on to things.
Never
but it is-
strenuously objected?
Right, like I heard he said he vehemently didn't disagree with something. I've never understood the difference between that and disagreeing. But it is what the case says, is all I can say, Your Honor. I don't really think I think.
Is it of no moment?
I wouldn't say it's of no moment. I think it shows that you are dealing here, as you just said a moment ago, there's an equitable nature of the rule. I think there's excusable neglect and due diligence are broad terms.
Well, and this judge, I can't speak for my two wonderful colleagues, but this judge thought maybe that's a part of this, that maybe that higher standard, and you're right, I'm not sure why that word tagged on to abuse of discretion, but maybe that presupposes some equitable component to this that this court needs to be deferential to the trial court about. Perhaps, and I don't know if the cases say that. I candidly have not read these older, I think there are at least two Supreme Court of Florida cases saying that.
Yeah, we cited obviously here when we say the standard of review. I'm not going to back off of it. But I think really this is an easy case to decide based on just the record. One of the arguments in the initial brief was, which you heard today, is that it's just not credible what Judge Wallace did. Well, y'all on an appellate court, you're not here to make credibility findings, but that's what's being argued to you. And so whether you want to call it gross abuse of discretion or abuse of discretion, or even de novo, you defer to the fact finder and all those standards. And he just doesn't like the finding of fact that Judge Wallace made that.
We're not here to make the credibility determinations, but we are here to determine whether those credibility determinations were legitimate. So our
Correct.
big question is, how much deference do we give when
Sure.
determining that?
Yeah, so I think, like, when you're talking to this case, you hear the whole, he said, she said, this is Mr. Humbert talking to the principal of my client, Mr. Ashurian, on a phone call, and what happened with that. So to me, unlike the case you just heard, which dealt with contract documents and a lot of paper that's being reviewed and what do those words mean, this is the highest level of deference, because it's what was said between the parties. And none of you have observed my client in person. Judge Wallace did. So didn't counsel as a witness, but he's not here today as a witness. He's here as appellate counsel, and he has to respect that Judge Wallace disagreed with his assessment of Mr. Ashurian. and so do you. So I think there's no higher level deference because of the nature of the evidence at issue in this case. To answer your question, Judge McIver, you can't, you're not in a position to second guess Judge Wallace on that. Maybe on that contract case you are. I'm not speaking about the last case, but I think there's just a difference when you're dealing with the evidence. I see I have 24 seconds left, so I think I've covered all the points I wanted to cover. If the court had any, Cedar Mountain, just real briefly. I kept hearing it was per curiam, which simply means it's unsigned. It doesn't mean it's any less authoritative. And I would just point out, former Justice Lawson was one of the 3 judges on that opinion. And all it did was read the rule, which is Rule 1.030. But we'd ask that you affirm the order below. Thank you, Your Honor.
Thank you, Mr. Gowdy.
Thank you.
Mr. Humbert, it looks like you officially have 2.5 minutes, but I'm willing to give you a little bit more time to deal with some of the things I brought up with Mr. Gowdy at the end that I said I would ask you about. But let me start with this equitable component. And I know you took exception with that statement on page 8 of Judge Wallace's order, but is there an equitable component here in this rule?
Not in the cases cited in the briefing that I've seen. As far as, and I think if there's an equitable component, it's going to go to the meritorious defense issue, which was.
Well, and I'm just looking. I've got the rule. I know you have the rule on motion and upon such terms as are just. That sounds like equity to me, perhaps. But then we've also got excusable neglect that also has a little bit of a feel of equity. So I mean, that's my question. Is that a feature here? The federal courts say it is. Is it a feature for us? Was it a feature for Judge Wallace below?
I believe it drove his opinion, and it ultimately, but if, the binding opinion on this court is, and I'm not familiar with those specific federal cases you mentioned, but the Joe Lynn case from this district, it doesn't regard equity as a material consideration for the excusable neglect. And I do take umbrage. It was alleged that I didn't raise this until in the lower court. On page 118 of the hearing transcript, I said, I not only cited the case, I gave Judge Wallace the citation to Joe Lynn. It was the only case I actually cited the full reporter's citation. So I cited it, and the fact that I put it in page 9 or 10 of my brief, it was addressed in my brief. So and also there was a representation that I have made statements that are not part of the record. There, if you look at the hearing transcript, there is plenty of testimony that Mr. Ashurian's wife, who testified on behalf of AASHTO, stated that they have accountants. That's in the record. That Mary Beth Mitchell, who's a name you're going to see in that transcript, that she may have not been a Florida bar attorney, but she was an attorney that worked there. So that's all part. I just wanted to clear that up, that is part of the record. And the fact that the Joe Lynn case, it is a very damaging case for AASHTO here, which is why I think there's a leaning on it being that it's somehow waived. I don't know what more I could do to preserve it or preserve the presumption. It was stated that I only said it once. I don't think there's an obligation for me to repeat this.
That aside, Mr. Humbert, I think Mr. Gowdy's point is that these facts are dramatically different than that case. I mean, starting with, we have a letter versus we have a conversation that was evaluated by Judge Wallace, meaning the conversation you had with Mr. Ashurian in this case.
But I'm agreeing for purposes of this argument. I'm agreeing. I'm not trying to challenge Judge Wallace's finding that Mr. Ashurian and I had a misunderstanding, and that Mr. Ashurian was reasonable in that misunderstanding. Accepted, premise accepted. Give him that benefit of the doubt. I'm not challenging that.
Yeah, but
That's the he said. It's all he said. He said, I agree. Fine. Mr. Ashurian's right. I misunderstood. He was perfectly in the right. Let's assume that. It's everything that happens after that's documented in all of these court filings that are served. You know what's if we're going to talk about equity.
But Mr. Humbert, that sort of begs the question, respectfully.
Okay.
I mean, if you go back to what Judge Wallace is saying, Mr. Ashurian believed that was it. We don't need to do anything else. So it's, again, of no consequence, according to Mr. Ashurian, if in fact he did receive more documents. I think, can't you read that order that way to say his misunderstanding, purported misunderstanding, was such that he just believed it was over?
I would agree entirely. If that was if that conversation had happened at the end of the litigation prior to the judgment being entered, I would agree with you completely. But it happened at the beginning, and then everything that happened after that completely contradicted what a reasonable person would assume that everything was resolved. It is so much worse. The facts in Joe Lynn are so much more in favor of just affirming. I mean, these facts are more egregious. Joe Lynn is a 3-page opinion. If you go line by line, no, a conversation, Ashko's conversation with me versus the letter in Joe Lynn. Okay, they both are non-attorneys that are corporate representatives, and they both had a misunderstanding. And even on those facts, this court found that the lower court should be reversed. But here we don't even have the 5 subsequent pleadings that occurred after that. And the idea, one more thing, regarding the waiver argument, the argument wasn't waived on at any point. Presumption simply wasn't given. There's no requirement in a non-jury setting that a motion for rehearing be filed as to findings of fact. Judge Wallace the presumption was not given, and that was the death knell of the entire opinion. And I think when you read Joe Lynn and you juxtapose it with these facts, the facts in Joe Lynn are worse. They just are. If there had been 5 additional papers that had been served on the plaintiff's lawyer, then we'd be dealing in the same world here, but there's not. So, and that's the only 5th District Court of Appeals opinion that I believe is on all fours as to the excusable neglect.
Thank you, Mr. Humbert. Thank you, Mr. Gowdy. It was very well presented on both sides. We will be in recess.
All rise.